Good morning and welcome to the October Mortgage Quality and Compliance webinar. This is Susan Milazzo with the California Mortgage Bankers Association. I'm very happy that you could join us today. As many of you know, this is a monthly webinar that we hold on a different compliance topic, and it is open to anyone in the industry. So if you have received the link to register for this free webinar through someone else, you can email me and I will be happy to add you to our distribution list going forward. My email is susan@cmba.com, and like I say, I'll be happy to add you to our distribution list going forward. A couple of housekeeping items. We will have the ability to ask questions at the conclusion of the presentation today, and we'll ask that you pose those questions in the question dialog box in the lower right-hand side of your screen. We're also recording this webinar, and it will be made available on our website. So if you would like to share it with any of your colleagues at your company as an educational tool, you will have the ability to do that. I'd like to start off the webinar today and thank our 2019 Mortgage Quality and Compliance sponsor. That's the Compliance Group. To represent the Compliance Group today, we have Jim McCracken. So Jim, I'll turn it over to you.
Susan, thank you very much for the opportunity to speak today, and welcome everyone, and thank you for joining us. The Compliance Group is a nationwide provider of origination, servicing, QC, and compliance audit services. We have one primary goal: keep our clients safe. Our team consists of highly knowledgeable, meticulous, passionate individuals. We hire and retain only the best. We engage in such a way that we become a critical component within the client's business. So our clients tell us our process, our staff, our quality, and how we communicate instills confidence and certainty. The bottom line, we want our clients relaxed so they can focus on what they do best, which is originate. If you are working with us already, thank you for your business and trust. If you are not a client but would like to find out more about our services, please contact me. Susan, back to you.
Excellent. Thank you so much, Jim. And again, thanks to the Compliance Group for your support this year. It's been greatly appreciated.
It is our honor.
With that, we'll move into our agenda for today. I'll turn it over to Carol Carson with Plaza Home Mortgage, who is our Mortgage Quality and Compliance Committee co-chair. Carol, take it away.
Thank you, Susan. Good morning, and let me add my good mornings to everybody else. Thank you for joining today. The first item in our program is a legal update, and it'll be presented to us today by Michael Pfeiffer, who is the General Counsel of the California Mortgage Bankers Association, and he's also of counsel with the law firm of Kirby & McGuinn. So, Michael, it's all yours.
Thank you, Carol. Good morning, everybody. I'm going to spend just a few minutes today talking again about the Seal of Law case versus the CFPB. For those of you who are on the call last month, this is deja vu all over again, but there's really a couple of not subtle, but really significant changes since then. So I thought, it's important enough. This is going to be one of the most important decisions, in my opinion, in our lifetime, dealing with the mortgage banking industry and affecting what we do. So I decided to go into a little bit more depth because of a significant event that happened last Friday. There we go. I reported to you that a petition for certiorari had been submitted to the U.S. Supreme Court, appealing the Ninth Circuit Court of Appeals decision upholding the constitutionality of the CFPB, and that I would get back to you if anything changed. Well, it has. Last Friday, the Supreme Court accepted the case for review. That means it's going to make a decision on the issue. They don't accept these cases for review unless they intend to speak on them and make some significant decision. So whatever comes out of this is going to be earth-shaking, probably, or at least significant for the CFPB, and is also going to, even if they, and I'll get into this in a little bit more detail, even if they only make some minor changes to the CFPB and leave the CFPB standing, that in and of itself is going to have some ripple effects across the way the way business is done among the agencies and in particular the independent agencies of the U.S. government. So what does all this mean for the industry? I'll explain, but I want to just give you a quick overview, or a quick review, I guess, of how we came to be in this place where the Supreme Court is deciding this. In this case, Sela Law LLC, the CFPB had filed a petition to enforce a civil investigative demand that it had issued as part of its investigation into whether a law firm violated the telemarketing sales rule. And the district court for the Central District of California granted the petition and ordered the law firm to comply with the investigative demand. And the firm appealed this to the Ninth Circuit. The Ninth Circuit was asked to basically opine on the constitutionality of the CFPB on the grounds that its structure violates the separation of powers in the U.S. Constitution because it allows the director only to be fired for cause, and that includes inefficiency, neglect of duty, or malfeasance in office, as opposed to just at will. And that means essentially that it's much harder to remove the director who's elected for, I think it's a 6-year term. Not elected, but who's appointed for a 6-year term. And in May, the Ninth Circuit filed its opinion saying the structure of the CFPB is constitutional, that the civil investigative demand did not violate the CFPB's practice of law exclusion and did not violate the Dodd-Frank Act requirements with respect to civil investigative demands. And then Sela Law petitioned for review by the U.S. Supreme Court. And as I said, they considered that. They were considering it last month, but on Friday they granted the petition. It's significant because this is kind of teed up to be as I say, a sort of a landmark decision. In connection with the Ninth Circuit decision, the CFPB and the Department of Justice had filed a brief basically supporting the CFPB, and then it was changed in connection with the appeal, with obviously the change in the administration, and the CFPB and the DOJ now are basically saying they've reconsidered the CFPB's position and decided that the removal provision is unconstitutional, and that the for-cause provision impermissibly infringes on the separation of powers, and the proper remedy is to sever the provision, even though Congress has not enacted a severability clause. And that's going to become significant because the issue ultimately becomes, is this something that can be fixed at the Supreme Court level, or is this something that will invalidate? If this provision is held invalid, does it invalidate the entire statute? The same day, Director Kraninger sent letters to the Congress, basically the Congress and the Senate, explaining the reasons for the change and in their position. And we went through those last month. I'm not going to get in there in too much detail, but I just want to emphasize the fact that in that letter, she acknowledges that she has directed the CFPB's attorneys to refrain from defending the constitutionality of the Bureau. That's a pretty significant thing, but that's a significant provision because it basically there's nobody to defend the position in the U.S. Supreme Court, and also saying that the DOJ is instructed not to defend the constitutionality of the CFPB throughout the country. Last Friday, the court granted the petition for the writ of certiorari, saying that, and I've quoted it here on slide 9, in addition to the question presented by the petition, which is basically the constitutionality of the for-cause provision, the parties are directed to brief and argue the question of if the CFPB is found unconstitutional on the basis of the separation of powers, can this provision, and this is the provision having to do with the for-cause dismissal, can that be severed from the Dodd-Frank Act? And so they're going to be looking at those questions. They also granted an amicus filed by the United States House of Representatives, taking the position that the CFPB is constitutional. That's not unheard of, but it's pretty rare for one branch of government, the House of Representatives, to actually seek to step in as an amicus. And there's all kinds of political issues obviously associated with that. If political alignment in the Congress had been different, then you'd see a different position. So you're seeing great movements here by the three main branches of government. Go back here. The Supreme Court basically has three choices, maybe a fourth. They can declare the single director structure constitutional, in which event that's going to put an end to a lot of the decisions that are out, a lot of the litigation that's out there. And there are other lawsuits that are pending. There's a case in the Fifth Circuit called CFPB v. All-American Check Cashing, in which a payday loan company has argued that the bureau structure violates the separation of powers, that the only solution is to set it aside completely. The Fifth Circuit hasn't ruled on that motion, and now it's not going to now, pending this outcome by the Supreme Court. There's another case called Collins v. Mnuchin, however you want to pronounce it, and that's also in the Fifth Circuit, involving Fannie Mae and not directly the CFPB, but the Federal Housing Finance Agency. In that case, they claimed that the provisions of the FHFA that also has a single director and with a for-cause removal structure, they argued that that was unconstitutional, and the Fifth Circuit agreed, holding that provision was unconstitutional. There's another case in Texas, arising out of the State Bank of Big Spring, Texas, in which the Supreme Court had denied cert. They were appealing that to the Supreme Court. The Supreme Court had denied it, and that's significant because Justice Kavanaugh, who had been part of the three-judge panel in the D.C. Circuit Court of Appeals on the PHH case, and had decided that the CFPB was unconstitutional there. Now he's on the Supreme Court. He recused himself from voting on that petition. You could probably expect him to do the same thing in connection with this decision, in which event then you've got political alignment that may or may not favor holding the CFPB constitutional. So it's not as clear cut as one might expect. In that decision, where now Justice Kavanaugh was involved, the District Court of Appeal had ruled that the single director structure of the CFPB was unconstitutional, but subsequently in January, the en banc D.C. Circuit found the CFPB was constitutionally structured. So you got all of these things that are tied up together, and I wanted to emphasize there's another course of action, which is that all independent agencies are unconstitutional, because they essentially constitute a fourth branch of government. In the D.C. Circuit, in his dissenting opinion at the en banc decision, Justice Kavanaugh, and I'm going to just quote this and conclude with this quote: "This case is about executive power and individual liberty. The U.S. government's executive power to enforce federal law against private citizens is essential to societal order and progress, but simultaneously a grave threat to individual liberty. The CFPB's concentration of enormous executive power in a single, unaccountable, unchecked director not only departs from historical practice, but also poses a far greater risk of arbitrary decision-making than does a multi-member agency." These are big issues. This is going to be a major historical landmark decision any way it comes out, and we need to watch it closely. That's my report. So that's my report.
Thank you. Thank you, Michael.
Go ahead, Carol.
It's fascinating and, as you say, a very important case, and thank you for monitoring it for us and keeping us posted on it. Now we're going to turn to the sort of main event of our presentation today, and it is about banking in the secondary market and how to avoid repurchase demands. And we're thrilled today to have two speakers. The first is Carmella Snytsheuvel, and Carmella is currently the Assistant Vice President for Compliance Operations at Impac Mortgage, and Carmella has 30 years or more. She started when she was 12, of hands-on experience in the mortgage lending industry, including loan processing, underwriting, operations, funding, third-party compliance. And as a mortgage professional, Carmella has served in various capacities, including branch operations manager, subject matter expert. She's been an independent consultant and a compliance operations liaison. Carmella has provided guidance to major lenders, brokers, originators, attorneys on regulatory compliance issues, from TRID to QM to HOPA, TILA, HPML, RESPA, and every alphabet soup regulation there is, as well as state laws and regulations. Her unique perspective provides clients the comfort that she understands the challenges that exist in today's mortgage industry in manufacturing quality, compliant loans. And joining Carmella today is Ingrid Petersen, and she is an attorney and the co-chair of the Mortgage Banking Practice Group at the law firm of Johnston Thomas. Ingrid is well-versed in all aspects of mortgage banking, including origination, underwriting, appraisal, title, mortgage insurance, secondary, repurchase, and make-whole litigation, trade secrets, unfair competition, and compliance issues. She's resolved many high-stakes contract matters. She's worked for clients in cases with Fannie Mae in getting requests for rescission of damage claims overturned. And in addition to that, she also has a background in tech industries, and so she is able to handle legal challenges associated with blockchain, enterprise, and SaaS solutions. So welcome, Carmella and Ingrid, and we're looking forward to hearing your presentation. Thank you.
Thank you, Carol.
Thank you so much.
So I always love The Princess Bride, so I had to start with this. The best start is knowing who your investor is and how they think, what their appetite for risk is, etc. So while you might not think something is significant, they could, and understanding their point of view helps you down the road when you have to tackle the disagreements that could occur. So my recommendation is, first off, start off building a partnership. Understand their requirements. Do they have specific overlays if you're selling a Fannie or Freddie loan? Do they have overlays on top of the straightforward products? As I said earlier, understand their appetite for risk. And, what is their due diligence process? Do they do it in-house or do they farm it out? And what is the period for repurchase that you have? And then also, you're going to have to lay some internal partnerships, the road work, because you all have secondary market that you're dealing with because they're pooling the loans. Post-close, usually may be the one spearheading the trade as far as the delivery of the documents to the investor. They may reach out to you in compliance. Again, you'd have to have a good rapport with your production staff. IT as well, and any investor relations or remediation team that you may have. So once you've established your partnerships, you can begin to identify any gaps that you may have, whether it be compliance or your systems or your processes. When you identify these, are you aggregating the information so you can determine, your patterns and practices? And are the due diligence findings, due to a document retention issue or a gap in your process? Do you need to make changes based on what you're finding, or are these one-off situations? And some things can be as simple as calculations that your LOS is providing versus what the due diligence is looking at with their calculations. I want to say one of the biggest things that we see from our investors is the differences of opinion centered around per diem interest, especially when you go into the month with an interest credit closing. Some will permit you to include it with your total of payments calculations. Others have a more conservative stake on that, and they will say, no, we don't want you including it. How do you come to a meeting of minds when this occurs? And then, also understanding when you take corrective steps as you make more sales and as you are delivering more loans to prevent these from happening in the future, how are you communicating this down to your staff when things change? Are you remaining agile enough that you can still continue to do your business without impeding future business? And then also, when you do have differences in your regulatory compliance interpretations, do you have attorney letters, attorney opinion letters or guidance that you can share with that investor, or even a regulator guidance? You can think about sharing with the investor, yes, we've vetted this out and it's even come up on a state audit, and here's what the state finally came back and agreed with our position. So that can lend credence to your stance and how you approach things. And then that infamous repurchase demand, is that the final say? Can you still rebut the demand? And again, sometimes it can take just a simple phone call with the investor. Sometimes you do need to dig into the file more and determine, can you cure it? Will they permit a cure outside of a 60-day if it's a TRID violation? Some do. Some don't have a problem with a cure made within 60 days of discovery. So again, also going back to engaging with your appropriate parties that can assist with mitigating the issue with the investor. Do you have a point person in your shop to deal with the investor solely so that it's a unified and single response and they're not bombarded from many different people? And finally, are there any other options you have not explored? Sometimes reaching out to a colleague across the aisle, that it can help just having that open chat. Many of us, as we move into the non-QM space now, will be finding new investors. And again, things that you thought you've already vetted out may have a change of differences of opinion on how they interpret things. So at this point, I am ready to turn this over to Ingrid.
Thank you so much, Carmella.
Carmella or Ingrid, can you? There you go. There you go.
Let me see. Can I advance the slide? Oh yes, I can. Wonderful. Thank you. So starting with, the infamous repurchase demands that Carmella mentioned, there's really two main strategies for preventing those The first is if you are in an existing loan purchase agreement relationship with an investor there, and you enter that existing agreement, you can, at that particular moment, renegotiate it. Of course, you can always go back to them and ask them, to amend the agreement. And, if you've entered into the loan purchase agreement without the benefit of counsel reviewing your agreement before you signed it, I would advise definitely, considering having counsel review it, because in my experience, a lot of lenders enter into these loan purchase agreements without really considering fully all the risks involved. But if you just, once you're in that agreement, going back to what Carmella was saying, I think the most important thing in terms of prevention is making sure that your underwriting staff are fully trained, especially for more complex loan products and situations. And the two situations where I see repurchases coming up a lot is in 203K loans and VA loans. And those are both loan products I wouldn't recommend anybody, originate unless you're very familiar with them. They're a lot more complex and have a lot more layers and steps to them. And then the other thing is really considering all of the investor requirements. There's, it's not simply the product, there's checking exclusionary list. Some investors have some really unusual provisions, such as not allowing brokered loans, not allowing loans subject to the SCRA. And so I think the big challenge is really integrating all of those complex requirements and nuances into your production process and having some kind of checklist or process where all of those items can get checked off and it's not an afterthought, and so that, everybody knows ahead of time what needs to be done for each loan. And then the other thing is that, of course, ideally, the ideal situation to be in is to, before getting into that relationship with the investor, is to first of all pick the right investor and negotiate terms. Every investor is different. Some of them are a lot easier to work with than others. Some are much more amenable to negotiating terms than others. And with experienced counsel, you can definitely get significant concessions from those investors that can be really helpful to you down the road. Say, picture 10, 15 years down the road when that wonderful, vice president of, business development that you're working with the investor is no longer around, and now you're dealing with a completely new person. It can be so helpful to have more favorable terms in place. So, one of the really complex things about the types of contractual relationships common in the industry is that we have these two documents. One is called the loan purchase agreement, and then there's the seller guide. And for some reason, over time, a lot of investors put provisions that really should be in the contract and the loan purchase agreement in the seller guide. So you'll have an indemnification provision in the loan purchase agreement, and then there will be another indemnification provision in the seller guide. And that makes the agreement very confusing and makes it difficult for you to negotiate it. So the first thing I generally try to do is to always make sure that the loan purchase agreement controls over the seller guide in the event of not just conflicts, but discrepancies, additions, so that both parties can be really clear on which term controls. And then the other very, negative part about these agreements has to do with the investor's ability to unilaterally update and supplement the seller guide, where you will have a provision in the loan purchase agreement saying whatever terms are added in future seller guides are going to become part of your agreement. That means that the investor could add a whole new indemnification provision into the seller guide, and you've already pre-agreed to that. So it's really important to address that, to say that, in the event that future editions of the seller guide conflict with what's in the loan purchase agreement, that the loan purchase agreement will control. Then moving on to the indemnification provision, this really has the largest potential for future liability and is really frequently litigated. There are a number of ways to narrow the indemnification provision. You can first look at what is subject to indemnification and try to limit that as much as you can. Is it just claims, losses, and liability, or is it just losses? And you want the number of things subject to indemnification to be as small as possible. And then the other key part of the indemnification provision is the nexus clause, which could be, something like resulting from, or it could be arising out of. And so arising out of is much broader than resulting from. So really we want that nexus clause to be as narrow as possible and to be something along the lines of resulting from, which implies a causal connection between the originator's actions and the law. Often courts interpret indemnification provisions as being risk shifting, and so it's really important to have it as narrow as possible. Then the other main provision of concern is the repurchase provision. Often, whether or not a lender really has breached its representations and warranties can be a matter of some debate. So before jumping into a situation where you are immediately required to repurchase, what you ideally want to have is to have a notice of the repurchase and then a subsequent opportunity to cure, where you have the ability to engage in a dialogue with the investor and set forth your reasons why it's not a breach of representations and warranties, not a breach of the underwriting requirements. And often the underwriting requirements are complex, and investors, like anybody, can get things wrong. And it's really important to have that ability to go back and forth, to ideally in writing set forth your position. And, if the repurchase demand is coming down from Fannie or Freddie, to be able to engage with Fannie and Freddie. You have usually a really great process for, rebutting the purchase demand. And Fannie and Freddie in general will rescind repurchase demands if you present them with a good argument. One big red flag is if you see sole and exclusive discretion anywhere in your agreement. Some courts have held that to mean that you really have no defenses because you've already given the investor the sole and exclusive discretion to determine what is or is not a breach. And so I always try to make sure that is absolutely removed. Then there's the offset and net funding provision. And this can be a really powerful weapon in the hands of the investor because they can just declare something to be subject to repurchase And they don't have to then go to court to try and get the money from you. They can simply say, oh, we owe you $50,000, but because you owe us $200,000 on this repurchase, we're going to net it out of that, and we're not going to pay you any of that money that we owe you. We're going to keep all the funds owed to you and apply it to this repurchase. And that's just something they can automatically do, but like the bank, taking a late fee directly out of your checking account. And, if you're owed a lot of money, it's something you really want to avoid. And, always try your best to remove those from the agreement, but if not, at least have the ability to secure and or cap the amount that they can net funds from what is owed to you. Reserves are a complex topic, and my only real comment here is be conservative, work with your whole management team, your CPA, and do your best to get as much input into making the decision on reserves as you can. It's not easy to determine what reserves should be, especially in litigation when, the results of litigation can be very uncertain. So definitely something you should get as much input on as you can. And then there's, another alternative, of course, is always to get private market insurance so that you don't have to tie up your funds in reserves. And that's something definitely worth looking into, and that you should consider, several different options before purchasing private insurance. And then there is, if you do get the dreaded repurchase demand, how do you address it? Typically, these deal with misrepresentation claims, although, I also do see compliance issues as well as occupancy being very common. The main thing is to first of all start by getting facts and documents that you need to review their claims, and to remember that investors make mistakes too. A lot of these underwriting issues are very complex. A lot of them are kind of rare and don't come up a lot. And often the person on the other side you're dealing with has maybe never seen this issue before and can make a mistake. So don't panic if you get one, because it can always potentially be resolved quite easily if you can explain to them the true meaning of the underwriting requirement at issue and so on. Just one thing to be careful about is that the audit reviews that you do are typically not going to be subject to any kind of privilege. It depends on the jurisdiction that you're in, but if the claims are litigated, whatever your QC department says is discoverable. So that's just something to keep in mind. There's nothing you can really do about that, but just be aware that, comments made by the QC staff, for example, someone sends an email to another person in the firm and says, this is definitely fraud or something like that, that's going to be discoverable, and it's maybe not necessary for the QC staff to make ultimate fact determinations. So that's something they should be aware of. Typically, even in talking with your attorney, getting business advice is typically not going to be subject to attorney-client privilege. Only legal advice is subject to attorney-client privilege. So try to keep the discussion to legal issues such as defenses, as opposed to purely business or QC discussions. And then finally, so, if you do have to repurchase a loan and you don't have those defenses, that's not necessarily terrible news because there's always the potential to recover some of those losses from a third party. Of course, the most obvious issue is, well, is this third party worth pursuing? Even if I get a judgment against them, can I collect on it? And that's something you can usually determine pretty easily up front by some fairly cursory investigation into who this party is, what kind of resources they have, and that's the first step that we always take in terms of considering pursuing a third party. So that's something you can do in-house or have an outside investigator do for you, but with all the third-party databases and publicly available data we have today, it's usually pretty easy to find that. And we've been able to get recoveries from brokers, even from borrowers. So, if the borrower has misrepresented themselves, we've been able to make clients completely whole through recovery from borrowers. So, every potential target is different. People have different sensitivities to the idea of being sued or involved in litigation. Different parties have different sensitivities to reputational harm. So, some people are presented with, the issue of you misrepresented yourself, will want to, pay up pretty quickly, get rid of it. Other people are going to be more resistant, but until you reach out to them, you don't know what response you're going to get. So never assume that a third party cannot be recovered from. Just final thoughts is that frequently repurchase is, just such an attractive prospect to lenders because it involves finding the money to purchase, $300,000, $400,000, $500,000 loan. But know that investors often do have the option, again, unfortunately, in their sole discretion of providing you with indemnification of the ultimate loss instead of repurchase, which for many lenders is a more attractive option. And, just do your homework. Don't assume that their loss figures are necessarily accurate, and always negotiate as much as you can, remove prejudgment interest, and but also be aware that, if you are unable to resolve it informally with them, many loan purchase agreements have one-sided attorney's fees provisions in which if they litigate against you, then regardless of whether you win or lose, you're going to be responsible for their attorney's fees, which is a huge incentive for them to litigate and makes it, cost prohibitive for you to engage in litigation. So the most important part is establishing that relationship and with the investor and really resolving it with them in that cure process, which should be available to you. And that's all I have on that. So thank you so much.
Okay.
Susan.
Okay. Well, thank you, Ingrid and Carmella. Really appreciate your participation and your presentation today. Now we will take questions. If you would like to pose a question to either of the speakers, you can use the questions dialog box on the right-hand side of your screen. While I'll wait to see if anybody would like to send in a question. I can pose it to our speakers. In the meanwhile, I will remind all of you that we've got our California MBA Legal Issues and Regulatory Compliance Conference. That's coming up December 2nd and 3rd at the Newport Beach Marriott Hotel and Spa. We've got some great speakers lined up. The California Department of Business Oversight Commissioner, Manuel Alvarez, will be there, as well as the Terry Theologis, who's the EVP and General Counsel at Fannie Mae. Great presentations by some panels that we'll have over the 2-day course. We will wrap in the afternoon on the 3rd with a California Consumer Privacy Act workshop. So if you're interested in participating in the conference and being a part of that workshop, we'd strongly encourage you to register. You can register online on our website, cmba.com. And I don't have any questions that are coming in, so, oh, you know what? I'm sorry, I take that back. I do see a question that's come in. Let me pose that. Here we go. Sorry, I was having some trouble. What are the best practices for establishing reserves for repurchase events for non-prime, non-QM versus agency? Ingrid or Carmella, do you have any thoughts on that?
I'm sorry, could you repeat the question, please?
Sure. What are the best practices for establishing reserves for repurchase events for non-prime / non-QM versus agency loans?
For establishing repurchase events?
Establishing reserves for repurchase
I'm
demands.
sorry. Oh, reserves for repurchase demands.
Yeah, what's the best practice for establishing reserves for the repurchase events?
That is something I think you have to really work out with your CPA and the management team. It's
okay.
not, yeah, I think it really varies from lender to lender and
on your own situation.
Upon your exposure to, what percentage of your loans are the non-QM versus QM.
Okay. Okay, Carmella, I have a question for you. In addition, that funding into the month interest issues you're seeing, what is the trend you're seeing due diligence companies pushing back on?
So one of the biggest trends that I see them pushing back on, not only that, is the cures. I have some investors that will permit you to change your lender credits with a valid change circumstance, whereas others will just take, no, you've disclosed this amount, and even though the appraisal isn't required now that it's eligible for a waiver, we want you to refund that entire $375 to the borrower as well. So cures are always a hot topic, and some of the analytics around the total of payments is the other thing that we see a lot of.
Okay, thank you. Attendees, any other questions? We're still taking questions. You can pose those in the questions dialog box. I think that might wrap us up for today. So again, thank you to Carmella and Ingrid for your presentations today. Carol, thank you for leading us through today's webinar, and everyone have a great rest of your day, and I'll hope that we'll see you at our conference in December. Thank you.
Thank you.
Thanks, Susan. Thanks, Carmella.